And further thereto, Mr. Suleiman was lying. Now, these are two conflicting versions of what the contents of the telephone call are that took place on that day. And my submission would be, in light of the absence of a detailed recollection, then what would be of sense is that Mr. Mokgotzi's version as to what was said on that day should be the one that stands.
There's a specific denial in 23.2. I deny that I suggested that if he could find evidence to implicate Mr. Karim, I would protect him from adverse findings from the commission. So that is a specific denial, and it goes to the very issue you are raising.
You in one breath, Commissioner, say that you don't have a detailed recollection, and in the same papers you say that you deny. How do you deny something that you cannot recollect in detail?
But that's a simplistic approach. Let us take the example of a person and their child. And the child says that on the 26th of April 2021, I had a discussion with my father about issue X. The father says, because of the time that has since elapsed, I do not remember that conversation. But there is no way, with the parenting skills that I have and the values that I cherish, that I could ever have said something like this to my child. I would never, ever. The parent knows what the values they cherish are. The parent knows what they could never ever say to their child on the basis that it would be at odds with their values. So the parent, even if they do not recall the conversation referred to by the child, is in a position to say, I could never ever have said anything like that to my child. I see nothing wrong with that at all. And that's basically what, in substance, of course, that's what Commissioner Khumalo is drawing to your attention. So the chief evidence leader is saying, whatever the detail of the conversation might have been, there is no way that I could ever have said to Mr. Mokgotzi, do the improper. I see nothing wrong with that. He may not remember the detail of the conversation, but suggesting to Mr. Mokgotzi that he should do something improper, he said, that I could never ever do. So I see nothing wrong with that. And your point about him in one breath saying this and in another breath saying that does not necessarily apply or necessarily make sense. Do you follow my point?
I hear you, Chair.
Yes, yes. I had said we would try to, or rather not to interrupt as much as possible, but sometimes we cannot resist it because of the submissions being made, because we want to give you an opportunity to argue your case as freely as possible. Yeah. Please continue.
Thank you, Chair.
I'm no longer inviting you to respond to what I said. I just want you to continue with your submission.
I'll do so, Chair.
Yes. I think before Commissioner Kumalo put a question to you, you were at a point where you wanted to deal with the role of an evidence leader in instances like these. I thought that's where you were. And I sort of assumed that perhaps you were going to take us to what Justice Nugent said in the SARS Commission or something like that. Maybe that's not what you had in mind, but once you started saying something about that role, I thought of what Justice Nugent said in the SARS Commission, in his judgment in the SARS Commission.
I will revisit that, Chair. I deviated from my chain of thought. I'm just recollecting. If I may be so permitted, Chair, may I take the commissioners to page 21 of the bundle. It's still the founding affidavit of Mr. Mokhodzi. And these commissioners will be in reply to the selective evidence that the evidence leader deals with, and this is the basis for the fear of where the bias might emanate from. If the commissioners look at paragraph 10, the applicant makes a reference to credible information that he had made available to the evidence leader and the leads thereto. And his take is that these issues, which he sees as important issues, have not been given sufficient investigative attention. And what is happening is that the interest has been directed towards specific individuals, and in brackets, it reads Suleiman. And further thereto, there's also evidence that came to the commission regarding the purchase of certain properties in the name of private individuals, and that has also been overlooked. And he further requested that these leads that he gave be given sufficient attention. And his take is that the individuals are not as significant or as important as this evidence that he has brought forth. Further, Commissioners, there's a point in limine that was raised, and this the Commissioners will find at page 260 of the bundle.
260.
260, Chair.
Maybe before you start on 260, can I just to make sure that I understand what is the submission or the argument about paragraph 10? Are you saying, is Mr. Mokhodzi rather saying that the failure, there is a failure, firstly, one, there's a failure by, is it the evidence leader, because this is an application to recuse Mr. Chaskotson, by the evidence leader to pursue his allegations that crime intelligence has brought properties, crime intelligence transactions, his evidence about a section 252A operations informant-related issues and procurement irregularities. Is the case being made that Mr. Chaskalson has failed to investigate those, and that failure has created an apprehension that he is biased against Mr. Mokhotsi? Is that the...
That is the position.
Okay, all right, thank you.
Please continue.
I apologize. I was directing the commissioners to page 260 of the bundle, and this deals with a point in limine that were raised by the applicant in the application for recusal. Specifically, it deals with the answering affidavit that was deposed to by the attorney purporting to be acting on behalf of the second respondent. There is no dispute that the attorney may be authorized to act on behalf of the commission. The dispute here is that the attorney goes beyond the scope of the institutional representation and purports to make factual averments on behalf of the first respondent, defend the personal conduct, intentions, and state of mind of the first respondent, who's the evidence leader. And they respond to allegations concerning private communications between Mr. Mokhotsi and the evidence leader. This attorney does not allege nor annex any proof that he or she has been authorized by the first respondent to depose to the factual matters on his behalf. The allegations that are raised against the first respondent relate to private WhatsApp communication, telephone conversations, alleged discussions, and alleged assurances of help or protection. The first respondent's subjective intentions and conduct, those are matters that are peculiarly within the personal knowledge of the first respondent. And the deponent, who is the attorney, will not be privy or cannot comment on these issues. Now, the affidavit of the first respondent has also been presented as an annexure. And there's certain value between an affidavit and an annexure. An annexure is merely a supporting document. And the attorney cannot make a case for the evidence leader and have the evidence leader's affidavit come in as an annexure, which seems to be confirming submissions by the attorney for the commission. I'm inviting the commission to find that when it comes to the affidavit that was deposed to by the attorney for the commission, that the commission finds that that affidavit does not enjoy locus standi. The issues that are contained in that affidavit and the comments cannot be of any value or any benefit because it's comments that they know nothing about. It's personal communication between Mr. Mokhotsi and the evidence leader. And it's issues that the evidence leader should be answering and not the attorney. Commissioners, there has been an explanation that was proffered in the replying affidavit regarding these deleted telephone calls or emojis.